before we start with anything else, I just want to take a moment and welcome our newest commission member. We have Dr. Ann Walsh with us here in Albany. She's from the New York State Department of Health Wadsworth Center. Dr. Walsh is the Associate Director of Medical Affairs and the section head of the Forensic Identity section. She's previously served on the New York State DNA Subcommittee. Dr. Walsh will be replacing Dr. Jenny. I believe that it was just earlier this week that all the papers were finally signed. So welcome. We're very happy to have you here as a member of the Commission, and thank you for agreeing to serve. We appreciate it. Now, with that out of the way, the next item we have is a review and approval of the meeting agenda. I believe the agenda has been circulated to all the Commission members. So if there are comments, that's fine. Otherwise, do I have a motion to accept the meeting agenda?
So moved.
And do we have a second?
Second.
All right, all in favor? Anybody opposed? All right. Now, we do have one item that was carried over from our prior meeting involving a executive session matter, and that involves we've had a request to speak with regard to the executive session issue from people from the City of New York. And to accommodate them, what I would like to do is just take that item first and just go into executive session to address that one issue. And so I guess technically what I should probably do is ask if we can have a motion to modify the agenda just to handle that one executive session item first before we do the rest of our business. Do we have a motion in that regard?
So moved.
All right, a second?
Second.
All right, all in favor? Is there any opposition? All right, there's no opposition, or having no opposition, then we will go into executive session to discuss a matter that could lead to promotion, demotion, discipline, suspension, dismissal, or removal. I would ask that anyone who's not a commission member or who's not a party with this particular issue leave the room for a period of time. We'll get you as soon as we go back into regular session. Oh, we're not. Are we? I
trust him.
Are we back on as far as the recording?
Okay, we good?
Yes. We're all set? Thank you. All right, we're back in regular session. My apologies to everyone who was waiting outside. We were working the entire time. Even though I'm going to report that we took no action in executive session. I thought someone would find that humorous.
Yeah, the guy that caused it all.
So with that, we'll continue with our agenda. The next item is the review and approval of the minutes for the December 11th, 2013 meeting. I believe that those minutes have been distributed. Are there any comments, or if no comments, do I have a motion with regard to the minutes?
Yeah, I have one comment with respect to the minutes, and it deals with another item that will come up, and that is I believe that it was during this commission meeting that I had made a specific statement at the very end to OCME leadership, Mr. Lean, Mr. Cooperschmidt, I think Mimi Mayers was there. I can't recall whether the Dr. Sampson was present or not. With respect to low template DNA, and ask them to take a look at the integrity of the underlying validation studies of Dr. Karagine in light of the Inspector General's report. And those comments, I think, have been transcribed, and I just want to note that they were made and for purposes of the record. And I think, Mike and Brian, you have seen those written out recently.
All right, any other comments? No other comments, and do we have a motion with regard to the minutes?
So moved. To accept.
Do we have a second? All right, all in favor? Anybody opposed? All right, so the minutes are accepted. The next items we have relate to accreditation and laboratory updates. I'm going to turn that over to Brian for this section.
Okay, the first laboratory is Erie County Department of Central Police Services. We have Dr. John Simich here, director of that laboratory. In your binders, you have a binding recommendation letter from the DNA Subcommittee regarding the DNA component of that laboratory. There's also a letter from ASCOD Lab granting accreditation from December 16th, 2013 through December 15th, 2018. And then there's an ASCOD International Final Assessment Report dated December 19th, 2013, which also includes the scope of certification of accreditation, scope of accreditation, and obligations of the accredited laboratory. So this is an item that will require a vote. If anyone has any questions, Dr. Simich is here and available.
Yeah, I have a few questions. Dr. Simich, with respect to the corrective actions, one of the things they said, the procedure for reporting mixture statistics is not completely appropriate. And so could you, mixture interpretation procedures does not include procedures for interpreting major and minor contributors, and the laboratory does not consistently deconvolute mixtures to include major and minor components. So what I would ask is if you could tell me, because I'm not familiar with your particular procedures, number one, when you deal with low template DNA and mixtures, what testing methodologies are you using? Are you using true allele? Are you using armed expert or any of those? What technology are you using, and what procedures are you using for interpreting mixtures?
Well, we're using the standard procedures that have been in place for many, many years for forensic labs. The auditors did not feel that the procedures that we had in place were as thorough or as definitive as they possibly could be. The changes that were implemented and accepted by NDIS and by ASCOD Lab were actually relatively minor as far as the changes to our procedure manuals. We are not using True Allele. We are not using Armed Expert at this time. We are actually have just purchased it and are in the process of training and validating Armed Expert. It's an excellent package. However, that does not do mixture deconvolution like True Allele does. So it's a totally different, it's more of a statistical package than a mixture deconvolution package. And it follows, Armed Expert does follow SWGDAM guidelines 100%, uses all the SWGDAM recommended formulas. So it is a little bit different. But that's going to take a while to get that online, and it has to be approved by the DNA subcommittee. So there's going to be delay for implementing that. But the procedures that we did implement were accepted. We don't do true low template where we do additional amplifications as they do in New York City or in England, in Europe. So at this time, so I'm a little bit at loss as to the specificity of your question. If you have more.
Right. So tell me. So you using YSTRs and you're using the standard STR packet, right?
Yes. Yeah, we use Identifier Plus.
Okay. And how when you're doing DNA testing on a mixture, do you have any? Have you done any internal validation studies on casework samples to demonstrate that you can perform the technology correctly and get adequate results?
Yes, all of our validation studies were reviewed by the auditors because we did get Identifier Plus online after our last audit, so we were last external audit, so that was part of the review process during this inspection. They did review our Identifier Plus procedure, and they agreed with all of the policies and the way that we're using that particular kit.
So to be specific about it, right, so to be specific about it, you demonstrated with internal validation studies that you could do casework samples using Identifier Plus for casework samples like swabbing a gun that had DNA on it, and you have studies that you showed to ASCLD that demonstrated you could do it. Is that right?
Yes.
Thank you.
No doubt.
Any other questions regarding Erie County?
Doc, I just had a quick question. Sometimes the commission we get a little concerned about the number. So there's 10 cars. But as I look at them, did you notice some duplication? I mean, I don't see the difference between, for example, car 10 and car number 2, car number.
Absolutely. Yeah.
Car number 9 or car number 3. I mean, it just
What
seems like
happens
it could have
is
been.
if they-
Not that it could have been like 6 as opposed to 10 as
Well, if there's a finding in one, for one standard, sometimes it also affects the second standard, even though it's the exact same finding. So that second standard is a separate car. That's how they're written up. It's my understanding.
But
how
your
that works.
corrective action is the same. And,
Yes, it was the same corrective action for more than
Okay.
one car, yes.
I don't know if somebody was mad at you or something. They wanted,
This is actually a fewer number of cars than average for a first-time audit is what I was told, so.
That's right, because you switched to ISO.
Yes, that's our first ISO.
All right. If there's no further discussion, I'd like to make a motion to accredit the Erie County Central Police Services in the disciplines of drug chemistry, biology, trace evidence, firearms tool mark, also in the category of other under impression evidence, footwear and tires, serial number restoration for a period that's mirroring their international accreditation.
So moved.
You have a second?
I'll second.
All right. All in favor?
Aye.
Anyone opposed?
Just clarifying, I didn't see Marvin or Barry's hands moving.
Do we have any abstentions?
Abstention.
I'm going to abstain, but I just want to be clear why I'm abstaining. I'm abstaining because of concerns about pattern and impression evidence, just in terms of its scientific validity, and not anything specific to the laboratory.
So there would be 9 in favor, if I'm correct, and 2 abstentions?
Correct.
All right, so that motion carries.
Okay. The next item on the agenda is the New York State Police Crime Laboratory. There's some information here that is just for informational purposes. There's noting of top management and key management changes that have happened in the laboratory. There's also a letter from the New York State Police to the DNA Subcommittee, and then a recommendation from the DNA Subcommittee, which will require action from this commission. We have Dr. Duesman, we have Lab Director Ray Wickenhausen that are present here in Albany that can answer any questions. In summary, I think this issue has been before the commission before. There was an issue about retention of records that, and again, you can clarify if I misstate anything, Barry, and I mean Barry Duesman, that records older than 15 years old based on the archival or the old archival system were disposed of, and then during a quality assurance review by the FBI's QAS audit, they went through and determined that you had to remove those profiles from NDIS and from ESDIS, correct?
Not exactly. It wasn't
Okay.
a QAS audit. We had actually made the inquiry ourselves to FBI
Okay.
prior to taking any action on the records. And they said that they should be removed, certainly at NDIS, and they have been removed at NDIS. At the state level, we thought we'd better come down and have it addressed by the subcommittee, and that's what we did.
Okay.
Barry, Dr. Duesman, why did the FBI suggest that these be removed? What was their claim?
It was in non-compliance with the QAS standard. I think it was standard 11, which said basically that, I have it right here actually, that the laboratory shall retain in hard copy or electronic format sufficient documentation for each technical analysis to support the result conclusion such that another qualified individual could interpret and evaluate the data. So that wasn't possible because the case files had been destroyed, so they said we should take them out.
And what are your procedures now with respect to preserving the electronic data in the case files?
Well, this was a rare event to begin with, and we expect that'll grow even rarer. We stopped destroying these records, and we've actually been doing a pilot project funded by NIJ, where we're having the records converted electronically, scanned electronically, so we'll be able to maintain them electronically and actually search them. They'll be a searchable database.
Well, are you keeping these records in another database?
Yeah, it's a proprietary database.
What does that mean?
Yeah.
It's the same company that's scanning our records is also supplying this database, which we're keeping them at least for the time being, and it has several advantages. I mean, it's made for this purpose, and it allows us, if we need to, we can scan the database for information.
So this is equivalent to a lab information management system. So it's really just a mechanism for keeping lab records of all kinds. So it's really a pilot project sponsored by National Institute of Justice, really to retain our records and allow them to be user-friendly in terms of searchability and so forth.
Yeah, our ultimate goal is to evaluate whether or not we can simply transfer them into an existing LIMS system. But for the time being, because we wanted to do this expeditiously, we contracted with this company to do this for us.
My question is that let's say that there is a crime scene sample collected somewhere in New York State, and you get a DNA profile. Would your proprietary database, which is no longer in the CODIS system, I take it, be searchable, and you could get a hit to the proprietary database? I mean, it's not just a LIMS system. Or is it? Or is it still functioning as a database?
No, it wouldn't allow for comparison, for example, between allele tables and such. That's not going to be part of the program. Basically, it's just going to keep the images of the information that we have now.
It's to take the paper records they were keeping, but only for 15 years. Mm-hmm. They're now going to electronically scan those paper records into a retainable electronic scan PDF or whatever file that's searchable because of proprietary data that makes the characters and words and pieces of the document searchable. So it's just to make paper electronic so you can keep it, because state archives hates to keep paper. So that's why they were being thrown away.
But I mean, does it have, if these profiles are no longer part of the CODIS system, is it still part of the Estes system? Is it still searchable in New York? I guess that's really my question.
If they keep the files, if they keep the data that they're now going to scan, they won't have to delete them from the CODIS system. So prospectively, they don't have the problem they have right now.
I see. That's for future
right?
future sample. Is that right? I just don't understand. So
I think the question maybe that we're trying to ask is, what are you doing with the profiles that you're deleting from Estes? Are you keeping that somewhere else?
Oh, I'm sorry.
Oh, different question.
Thank you, Catherine.
Question, actually, that we are maintaining, the subcommittee could not part with those. They wanted to hang on to them, so we are putting them into LDIS. We're clicking them off, so they're no longer in Estes, but they'll be retained in LDIS. So all the information will still be there, but it won't be searched as part of our normal Estes search.
Right. Just to add to that, so under the standard, these would not qualify for the national database or the state, but they would qualify for local. So DNA subcommittee was to just hang on to those profiles, and they would be eligible to stay at the CODIS.
Yeah, no, this is, thank you. Dr. Corrado put her finger on the question. We have a problem that also, I think, still exists with within other laboratories, and that is, what do we do about these local databases, which technically are not covered, I believe, by our statutes? Because, I'm not suggesting that you would do this, Dr. Duseman, but you could, in theory, take all these samples and conduct familial searching. You could do all kinds of things with this local database, and they're not specifically regulated, I don't believe, by any statute. So I think I commend to my colleagues the idea that I think we really should be working with the state legislature to clarify what we're doing with these samples in these offline databases that are not eligible for CODIS upload.
Without addressing that issue broadly with regard to other labs, with regard to this particular issue, I would note that there's a March 7th letter from Jack Ballantyne, the chair of the DNA subcommittee, to me as chair of the commission. I'm basically indicating that the DNA subcommittee directed that this issue be brought to the commission, and also indicating that the DNA subcommittee intends to further discuss the issue of what happens to these profiles at their May 30th meeting, if I'm reading this correctly, and they intend to make further recommendations to the commission after that meeting with regard to what happens to these profiles that are taken out.
Yeah, I would just note that it may behoove us, and I don't know in what form you want to do this, Mike and Brian, but in terms of communicating with the DNA subcommittee about this, there's a whole issue that I know Bill Fitzpatrick has been interested in, a lot of us, and that is what are we going to do about so-called partial matching or familial searching? And what do we do about protecting privacy in all these records? We have a patchwork system here. Some of us, including the late Judge McQuillan, believes that this has all been done outside statutory authority. And I think that we really have to come to terms with this. When I saw that communication from the DNA subcommittee, I think that it was almost like an invitation for a policy discussion as to how we're going to deal with this data.
I think,
particularly with the advent of CODIS 7, where you can do match and kinship probabilities with the FBI software itself. This is an issue that we really have to deal with in a serious way.
and I would suggest that for now we confine our discussion to the case in front of us. As I understand it, what you're saying is you want to take these samples out. You've been directed by the FBI to take them out. The subcommittee said it's okay, but come here. And the issue is, what do you do with those? Destroying them obviously has some implications. If I understand Barry's concern correctly, he doesn't want them in some type of database that's subject to searches that are beyond what's allowed by law. So the issue is, how do we keep them, but keep them in a way that doesn't allow them to be used improperly?
There are two actual different things going on here. The samples, the DNA records that we want to remove from SDIS, there are only 9 of these right now. And we're simply going to click them off at SDIS, and they will revert to LDIS. They'll be maintained at the local level. Okay, so we'll maintain them in-house at our local level. The other thing, though, is going forward, we don't want these to accumulate. So we're taking our actual case files in those instances, and we're scanning those electronically so we can maintain our records. So the actual few samples that we have at SDIS that the FBI wants us to remove are not going to come outside of CODIS. Okay, those are going to remain in CODIS, but at a lower level, and they won't be searched. But they'll always be there. And all the accompanying information that's with them right now will be there. The other thing we're trying to do is basically just to take our case files and scan them so we have them in the future, and they're not being destroyed.
No, I get that. And I'm just, with regard to those 9 samples that you're taking out, you're not starting any, searchable database where you're going to do familial searching or any other type of searching for that matter.
No, they'll still be within CODIS at the local level, which was where they originated in the first place.
All right. In the DNA subcommittee, I assume you'll be addressing the subcommittee on the 30th when they...
Absolutely.
All right. And then we'll get a recommendation. We'll get a further recommendation from them. Any other questions for the state police on this issue?
I'd like to make a motion to allow the state police to take these samples out of Estes with the understanding that they will come back before the DNA subcommittee at the May 30th meeting to address the disposition of those samples, and that will most likely come back again to the commission after that.
Second.
Any discussion on the motion beyond what we've had? All in favor?
Aye.
Anybody opposed? And any abstentions? One abstention. Superintendent? Thank you.
Next on the agenda, we have, for informational purposes, some information from the Yonkers Police Crime Laboratory. I believe at the New York location, we have Ms. Colleen Lockhart, the lab director. If there's any questions, not sure if she is, if she can approach. There's essentially just a, hello, Colleen.
Hi,
There's
Brian.
just notification, Ms. Lockhart was an acting director in term after Mr. Cheney had retired. She is now the full-time director. There's also some other updated information and some annual report information. So again, there's no vote required. This is purely for informational purposes. If anyone has any questions, Ms. Lockhart?
Congratulations.
Thank you.
You sure you want to do this? I just have one question about latent print examination. Have you given any consideration to, we went to some great lengths to get the protocol of the Federal Bureau of Investigation on, I guess what they're calling linear ASV, where you first score the latent, make a record of it, and then and only then look at the target prints and then make records. Have you given any thought to using that as you go down the
Our
line?
laboratory is not responsible for latent print identification. We only do latent print development. The latent print identification is handled by someone within the police department. It's not covered under the laboratory.
So the laboratory doesn't even, so when you say latent print development, you mean that the enhancement of prints?
Correct.
Okay. And will you make a finding as to whether there's sufficient information to go forward with further identification?
No, that is also done by
That
the
also is
police
by the
sergeant.
police department? Okay, thank you very much. I understand.
Okay, thank you, Ms. Lockhart.
Thank you.
Next on the agenda is the self-declarations of compliance with the ASCLD Labs policy on measurement uncertainty and measurement traceability. What you'll find within your binders are both the measurement uncertainty and measurement traceability policy. At this juncture, all New York labs that are ASCLD Lab accredited are part of the ISO program and must declare their to make these self-declarations of compliance. So what you find is the policies for both measurement uncertainty and traceability within the binder, as well as the laboratory self-declarations. And again, these are for informational purposes. There is no vote required.
I have a question.
Yes, Marvin.
Currently in New York State, although ASCLD Lab has implemented this measurement of uncertainty and all labs have to now calculate a measurement of uncertainty. Do we know currently of the 19 laboratories?
I'm sorry, Marvin, I didn't catch the last part of your question.
Do we know now how many of the 19 laboratories under our jurisdiction have agreements with law enforcement agencies who are their customers not to report measurement of uncertainty on lab reports?
You ever heard of such a thing?
I really don't understand what your question is, Marvin.
It's very simple. Under ASCLD Labs rules, although the labs have to calculate a measurement of uncertainty, and it is required, if a customer of ASCLD Lab, namely a law enforcement agency, has a request into the lab that it not report measurement of uncertainty as part of its lab findings, that's okay for ASCLD Lab. My question is, do we know of the 19 labs that we have, whether or not any have such agreements with any law enforcement agency?
I'm not aware of that part of the policy. Could you direct me to a part of that policy that shows that?
I don't have it in front of me, but I want to be sure that
Well, the policies are in the
That's how I
binder,
read it.
aren't they?
Yeah, the policies are in the binder, and I'm not sure of a caveat that allows people not to follow the policy, and that's the point of the self-declaration. But if you could direct me to a specific issue, I can address it.
If you look under the tab of looks like MU/MT compliance, the policies are both there.
I'll look for it. I'll come back to it later. You just put it at the end of old business, I'll have it for you.
Okay. Anything else on this particular issue? All right, we're next, we're now at old business. The first item we have on old business is we have a letter dated March 7th from the DNA Subcommittee addressed to me as Chair of the Commission. It's in the binders. It's the first thing under the tab of old business regarding partial match policy and migration to the CODIS 7 software. Every 2 years, it's my understanding, the partial match policy is reviewed. This recommendation comes as a result of the DNA Subcommittee review. Again, this letter is for informational purposes. I don't believe there's any vote required, but is there any discussion or comment with regard to the letter?
Yeah, I'm a little unclear as to what is the current partial match policy. Because I know that there were some considerations of changing it in terms of when YSTRs could be done and what process had to be gone through. Does anybody following that? I know that we issued a long letter in regard to this that gave a very complex explanation of the regs. You recall that?
Barry, I guess I'm not sure of your question, but, there was a written policy. It was my understanding the written policy was circulated to all the commission members. I think you were on the commission at the time that happened, and as I read this and as I understand it, they're saying they've done their two-year review, and that same policy stays in effect. I don't know.
There was a discussion that took place where a recommend that I actually attended. Brian, I think you were there, and it had to do with the New York City Police Department had been trying to do investigations with partial matches, and they found that they were not particularly informative, and they weren't able to actually get anywhere in any of the cases, as I recall. And Chief Pulaski was upset about it, and then there were some suggestions made with respect to changing how that partial match policy worked in terms of when there had to be authorization by the law enforcement or the district attorney's offices with respect to when you could move ahead and do YSTR testing. And then there were questions as to whether the DNA subcommittee, they were going to review the actual data from the 30 cases because there was a belief that if we actually looked at those cases and figured out what other kinds of DNA assays could be used that would be more informative, then we would have a better basis for understanding what might work or might not work. And in fact, in the meeting that I attended, and I'm told that in the last meeting of the DNA subcommittee, a number of those members were saying, well, we have to move to familial searching, or we will be proceeding with familial searching. And I don't want to be a stickler on semantics, but it's the state law and policy that we don't engage in familial searching. That is at least what the regs and the state statute says. But I'll be the first to concede that partial matching is indeed a form of familial searching. So I just want to be clear, and maybe, Brian, if you could make sure that it's sent to us as to what the quote-unquote current policy is, because it was my impression that the subcommittee never acted on the recommendations that had been made prior, and they were awaiting the raw data from the police department.
We certainly can and will circulate the partial match policy again to all of the commission members. In terms of the subcommittee not acting, I think the March 7th letter that's in your materials indicates the action that they've taken. But we will, at your request, we'll send you that policy.
Right. I'm just noting that they don't include a policy, so it's unclear to me how they're acting. And then I'm just noting for everybody's purposes, a very serious question. My understanding is that the subcommittee scientists, at least, are saying things like, well, we have to do familial searching, we have to move on to familial searching. And I understand the impetus for that. That technically speaking, that is not the policy of this state. It explicitly isn't. I would be open personally to looking at court-supervised and sunsetted procedures to look at the question of familial searching. And correct me if I'm wrong, but CODIS 7 software does have now some methods that could be used for determining relationships and matches that ordinarily would be done by the state. And that's coming down the road, and that's what the reference is here to the CODIS 7.0 software in terms of these issues. No?
Just for clarification, the last meeting of the DNA subcommittee, which occurred on March 7th, which I attended, the discussion of familial searching only occurred in the context of the FBI's familial searching policy. What they did is they reviewed and did a very comprehensive review of the partial match policy, including 2 members of that subcommittee, specifically going to the New York State Police and spending the entire day going through data. All members of the subcommittee received the data, went through the data. Those 2 members went through in great detail, spending an entire day of their time, which we're thankful, both Dr. Beavers and Dr. Kidd, to actually review and say that this policy is in fact effective. Also correcting an earlier one, New York City did actually have 1 successful partial match case. It didn't lead to arrest. It identified a suspect who actually had a reason for being in that location, but the actual procedure did in fact work in New York City.
All right, we will get to that policy, Barry.
Thank you.
The next item we have is an update with regard to the New York City OCME Department of Forensic Biology. There's a letter from the OCME to the Commission dated January 6th. I'm sorry, it's from the Commission to the OCME regarding the as-clad lab review being conducted at OCME. I believe that that review was conducted approximately 2 weeks ago. I understand that the review is concluded. I think there was a death in the family of the assessor, which has delayed us actually getting a report. But we anticipate receiving a report shortly, and that we should have something for the June 20th or for the next commission meeting. Any questions or comments with regard to that item? The next item we have is an update with regard to report standardization. Brian, if you can start with that.
Sure. You should have received a supplemental binder or a little mini binder, which actually starts with a letter from NICLAC, and then after, actually it starts with a table of contents, and after that a letter from NICLAC, and then some report standardization material after that. So I think for the most part, this is something that's been a long time in coming. I know a lot of commission members have been looking forward to kind of looking through this and reviewing this. I want to clarify that I do not see this as the end of this project by any means. I think this project will have a life of its own ad nauseum. But what I can say categorically, and as a scary statement as it is, this is the best that exists right now in the world, because nobody else has actually attempted or moved to this level of report standardization, not even in other states and other countries. It just doesn't exist anywhere else. So while this is an imperfect document, and I'll stipulate that to the beginning, and I was not contributory necessarily to the content, I was more of a shepherd, helping Dr. Corrado as the chair of NICLAC and the Twigs, maybe just giving some structure again to how this process worked. What happened was when initially charged with it, New York State, the crime laboratory directors charged their Twigs, their technical working groups in the different disciplines, to actually go up and come up with report standardization, to tackle the topic of report standardization. And some of the things that got exposed in that process were, we even noticed certain disciplines that are accredited in the state of New York, like crime scene, did not have a technical working group. So we had to create one in the last minute. So you'll notice also that their product is not nearly as comprehensive as some of the other ones that have been talking about this for a long time. But then after that also, each of these technical working groups had to engage in some pretty significant discussions about what is the best way to go about this, what is the best way to achieve standardization. So what was essentially achieved was three things that would make a report standardization. It wasn't that a report in the state of New York would be identical no matter what jurisdiction you went to, because there's customer needs that need to be taken into account. But to that effect, what happened is each of these reports, depending on what jurisdiction you are, would still have set components. And those components would be identified by the disciplines, and for the most part, NICLAC tried to actually make sure that those components were consistent throughout all the disciplines. Then after that, they tried to address report wording and standardized definitions. So I think a significant part of this was actually narrowing down what report standardization is to allow the crime laboratory report to be functional to the criminal justice system, to be out there, to make it usable to everybody, i.e. the definitions being standardized among all laboratories and also being uniformly accessible, and trying to move through, trying to come up with different language. And it has been challenging, and at times when it couldn't be resolved, and as I said, I was not a content creator, but I was more of a family counselor sometimes when people were having some heated disputes. You know, one I'll point out had to do with some DNA terminology, and currently SWGDAM, which is the current mechanism for mandating what DNA labs do, talks about cases where you say cannot be excluded. But there's a lot of, there are two lab directors that were feeling compelled that that's confusing language. So they wanted to say can be included. Now, if you look at what that statement means, it's really meaning the exact same thing. But the thing about it is there are people that feel very fundamentally that they don't necessarily convey the information in a usable format that will allow jurists to come to the right conclusions. So in those cases where we couldn't get everything together, I tried to note where that was. And as I said, this is an imperfect document. I'm not, I noticed actually some mistakes going through it myself. So I think what this is this is a document that we'd like to put forth for your comment. I know NICLAC is meeting next week, and I think any comments that you have, we'd love to take back to NICLAC and continue to improve it. I personally would like to see a little bit more tweaking to it along the way, which I think we can continue to do, and I think everyone is excited and wants to participate in. But once that step goes, I would like to start a dissemination method where we start this. And while it is an imperfect document, it is significantly better than anything else that's out there. And I think, using fortune cookie logic, the greatest journeys start with a couple of footsteps. So I think having the labs come in self-compliance with these guidelines, which will require them to change their regulations, change how they do it, and then after that having customer training, which I think DCJS can facilitate through our live meeting platforms to make sure that people understand why these changes are occurring and what's going on, and then constantly monitoring this process for improvement. I think, as I said, I think it's a great first step. But after that, I'd like to put it out for discussion.
And before we start, Dr. Corrado, is there anything that you want to add? I don't want to put you on the spot. You don't have to.
I don't want to repeat everything Brian said. I think if you read the letter that NICLAC wrote, it's very similar to what Brian said. This was a really involved process. A lot of people, I have to thank the twigs and the state, the examiners in the state spent many, many hours and a lot of arguments, as Brian said, and we came to what we thought was the best we could in coming to some kind of agreement on standardized terms. I think, as Brian said, it is a work in progress. Our goal is to continually improve this, and I think we have to see how it works. We have to implement it and see where the issues come up before we realize what we might need to tweak as well. So we would just, as Brian said, we were supposed to meet 2 weeks ago at NICLAC to discuss some of the issues, and we had to cancel the meetings with the storm. So we are meeting next week, and and we will meet again on this continually. So if anyone has any concerns or questions or wants to bring something to our attention you'd like us to look at, please do. We're open to the comments.
So the goal is to refine this periodically over time, and then all the labs will reach a consensus and they'll agree to follow these standardized
Well,
rules?
we are right now we're saying this is our first attempt, and the labs are going to there might be some tweaks to it, but we hope to be in full compliance with what we have here, hopefully by the end of the year, let's say. It's going to take a long time for people to change their procedures and get their report templates correct. There will be tweaks, so we'll try to be in voluntary compliance, and then as we change things, labs would continually, improve, make the changes to meet those changes that we have in here.
And then would it eventually become part of our accreditation process to say to each lab, when we have a final report, to say you have to be in compliance with this report to be accredited? Is that the goal?
I don't believe so, and I think actually it's inadvertently going to be that way, because what's happening is by laboratories coming forward and coming into voluntary compliance with it, what they're doing is they're already self-incorporating into the documents that they are accredited by. So it will be a standard that they're accredited by, but it's because the laboratories are making a conscious decision to do this. We've seen this before with New York State Labs when the Justice Task Force made a recommendation about additional documents, so that way people didn't think the one-page report or two-page report they got was everything. So now every report in the state of New York has a qualifying statement or disclaimer statement, however you want to call that, that says that there's more information and it's accessible. So those are things the labs did voluntarily, and what we see in New York is laboratories are also looking to do this voluntarily. One other thing I just might want to point out that's interesting is I think New York has a unique mechanism for actually making this happen. I recently had given a presentation about some other efforts that we were doing, and part of that presentation had talked about the structure of NICLAC and the technical working groups, and we were able to actually poll the audience, and it was actually amazing that New York is one of the few states that has these technical working groups and that has this organization of lab directors that allows this to happen. So I think, again, there's a lot of times that we chide ourselves that we're not doing as much as we can because we all feel very passionate about what we do. But when we compare ourselves, every now and then, when you step out of the microcosm you're in and start looking at the rest of the country, you actually realize that we're way ahead of the game with some of these things. So it's not perfect by any means, but go ahead.
Well, I want to thank NICLAC and the Twigs, and this is an extraordinary first pass, if you will. I mean, as you say, it will change. The idea of standardizing the definition so that when you use a term, we're all in agreement that's what it means, you know, inconsistent, insufficient, in whatever, is an extraordinary step forward. You know, yes, there'll be tweaking. Yes, it'll turn out some lab didn't quite use it the way it was defined. The thought of trying to say to all labs, you'll all have the same format, you'll all report it, and you're not going to get there. And so this is a huge step. It really is a huge, I mean, I haven't read every definition, but it's a huge step forward. And will be used as a model elsewhere, I'm sure, because the amount of time and effort. I can't imagine the world of clinical labs doing this. So, yeah, huge step forward.
We're also trying to put steps in place to actually account for change. So one of the things is we're looking at DCGS actually hosting some of these definitions, while labs will have the option of including the definitions within their report or having a web link to those definitions. But the reason for this also is as this process changes, we want archival information. So that way you can say these definitions will be for these disciplines from this period of time, reports from this date to this date. So that way if there is a change made, there's not something that contradicts itself. It's going to be something where if a defense lawyer or a prosecutor is prepping for a case and it's 3 in the morning the night before because they have 400 cases, they can access that information and they can see specific to the report because maybe it took time to get through the criminal justice system. Well, I have a report from 06. 06 would be this list. 010 or 10 would be this list. And you'd see what those definitions are and you could see if there was a change, why. So as I said, it's you know, I'm ready for the tomatoes to come. But as I said, I think, while imperfect, I think it's a great first step. And we welcome anybody's input as to where to go with it.
Any other comments or feedback?
Yeah.
Barry.
Let me join with everybody in complimenting and encouraging NICLAC for taking this first step. It's a very good thing to do. As my mother-in-law used to tell me, self-praise stinks, but we're supposed to be better than everybody. We've had a commission for longer than anybody. So I really just do expect the best. And I think that this is a great first step in that direction. Let me make some constructive suggestions along these lines. And if all of you correct me where I'm wrong. Ultimately, all of our labs are going to be ISO accredited, right? How many are now going to be ISO International accredited?
Right now, all the labs that are ASCLD are ISO, but there are also, I believe, 8 toxicology laboratories which are accredited by ABFT, which is not
right.
ISO.
So one thing that I would suggest that may be of assistance, because I think Bill Fitzpatrick's question was right on point in terms of how this relates to accreditation, is that Dr. Corrado, it might be good for you and your colleagues to, I'm looking actually at page 2 where project area number 1, standardized report components, and then you list quite a number of things there that you're trying to achieve, I guess, as you go through the different disciplines. And of greatest interest, I think, have to do with reports and conclusions, and also the case file, what should be available. And what I would call to your attention, and if you guys could do this, I think it would be terrific, is try to take these different sections and relate them back to ISO 17025. So, for example, I would say that with respect to the file that should be available, which is Statement 11, I think this is actually what the Justice Task Force caveat concerned, and that is that if a defense attorney or a judge gets a report, or even a prosecutor gets a report from a lab just stating its conclusions, there has to be a caveat saying, although you would certainly hope that people would know this, that the report does not constitute the entire case file. In fact, what I think would be useful is some kind of an affirmative indication from the lab as to what the case file is and where it could be found if another expert wanted to be looking at it. So, for example, under ISO 17025, under the section Technical Records 4.13.2, 1 and 2, there is a very, very helpful and I think appropriate and scientifically appropriate suggestion that the laboratory shall retain records of original observations, derived data, and sufficient information to establish an audit trail, calibration of records, staff records, and a copy of each test report or calibration certificate issued for a defined period. And then it goes on to talk about what that means, as well as 4.13.22, observations and data calculations shall be recorded at the time they are made and shall be identifiable to the specific task. And so I think if you go back and take a look at the ISO requirements that ultimately the labs are going to have to meet and try to apply those to each of the different disciplines in some fashion or form, that may assist the process. And I would commend 4.13.2 to be almost explicitly referenced when one talks about the case file and the technical records, because I think the whole point is to have a record available for somebody to look at that can do an audit trail or replicate the test. Indeed, I'd note that that is, I think, one of the reasons that the CODIS system, got rid of those 9 profiles because the records they didn't feel were there for them to do an audit trail. But I think that's coming. Secondly, with respect to reports and conclusions, I hope you're all aware that the latest recommendation of the Justice Task Force is that that experts come into court and comply with the federal rules of civil procedure with respect to reports to the court. And that's a big, big change, and really quite a bit more rigorous than what is currently in practice in the state courts. Now, obviously, that does not have the force of law, but it's something that I think NICLAC should take a look at to make sure that all the labs can prepare themselves to be in compliance with proceeding in the fashion of the federal rule of civil procedure. And finally, with respect to reporting results, I would call your attention to the section of ISO 17025, section 5.10, with respect to report writing. And in particular, when it talks about, in the second paragraph, the results shall be reported, usually in a test report or calibration certificate, and shall include all information requested by the customer and necessary for interpretation of the test or calibration results and all information required by the methods used. And then it goes on to refer to some other characteristics. Now, the way that I would construe this, and I think it would be helpful if NICLAC would address it specifically in light of the Inspector General's report concerning the Office of Chief Medical Examiner and the DNA results, and that is the customer, I think, should be regarded as the court system. But even if you just take a narrow view and regard the customer as the district attorney's office, which I think would be too narrow a view of this matter, the district attorney would need to know, and certainly the court system needs to know, as, quote, necessary for interpretation, any disagreement between examiners in any particular assay. So if, as in the OCME situation, we had disagreements about the interpretation of low-level mixtures of DNA between different examiners, all that has to be recorded in the case file as the Inspector General recommended, and that should be true for every discipline, and it should be documented. And I do read the ISO standards 5.1.101 as requiring that, and that might be something that all of you would seriously consider incorporating into these standards. So I realize that's a lot, and if you want, Dr. Corrado, I'll send you that and some more specific interpretations.
You actually don't have to, Barry, because we've actually talked about this a lot, and they're good points that you raise. And first off, what happened is the actual components and when this the different things that are in here are specifically written to meet the ASCLD guidelines, the ISO guidelines for the different laboratories, and the ABFT guidelines as they come through. The different guidelines from ASCLD that you were citing talk about this documentation being part of the case file, which doesn't necessarily have to be the report. And we've also spoke with ASCLD Lab about that to ensure, as we're moving forward on this progress, we also believe if there's disagreement between analysts, that should be documented, and the place for it in this particular case is the case file, because that's where you could do the most appropriate documentation that you actually have it. So the points that you're bringing up are good ones, and they're ones that all the twigs have actually discussed, as well as NICLAC. What we're trying to do here is ensure that first off, it's not just the ISO guidelines that these are based on, but there's other guidelines as well as at the time, my soon-to-be 12-year-old was used a lot for definitions. When we try and come up with the idea of how do you know what terms have to be defined, and I was trying to use, as a family facilitator, well, if I walk up to a janitor or a secretary, an 11-year-old, a 12-year-old, and say a term, if they know it, you don't have to worry about defining it. But if they don't, that's something you have to look at defining. So I appreciate your input. Again, if there's anything else, by all means, feel free also to email us and to have some more technical stuff along the way. But the points you bring up are good, and the ones that have been considered during this process.
I understand. And just to be specific about it, I do think you should specifically reference those ISO guidelines and if you are indeed taking the position that the case file is the place that any disagreements between analysts is ultimately recorded. I'm not sure that that alone is going to be sufficient to get the attention of a district attorney who's looking at a lot of different cases. You may want to consider other internal guidelines in light of the IG report that make clear if it was a particularly controversial case. Remember that most cases are disposed of pursuant to plea agreements. So I think it's very unusual for people to be actually going back and examining the entire case file in a matter that may be a plea. And district attorneys, I think, want to know before they even entertain the plea bargaining process, as well as the court and defense lawyers, is as to whether or not there was any controversy, disagreement, problems with respect to any particular assay. So you may consider including that kind of thing in the actual report. But we will make some specific suggestions. We will email them to you. And again, I congratulate you on undertaking this effort and commend to your attention the recent action of the Justice Task Force.
Any other discussion? As a chair, I want to thank NICLAC for their work. I think as Ann pointed out, this is a tremendous amount of work, for a group of people that's already overworked. So thank you. We appreciate your work. Brian, thank you for your help on the process.
I was going to just say, if you would let me, thank you for that. I think all the lab directors and all the examiners that worked on it appreciate that. But I also want to thank DCJS because having someone at DCJS to help keep track of all this has really helped. And we appreciate the ability to put things on a website so there's a place for us to document all of our archival stuff too. Thank you.
All right, the next issue we have is an update with regard to our hair comparison survey. Again, Brian, if you can start us on that issue.
Sure. And what happened is we, I think, a little subset of the commission, I think DA Fitzpatrick, Kathy Corrado, I'm trying to remember, I think Marvin and Peter were on a area that came up with a hair survey. So what happened is in your binders you'll find a blank copy of that hair survey. What happened is now you have a little sub-binder that has the results, and also in that is a summary table that's up front. So what this does is the first part of the summary table will actually indicate who's doing hair analysis. Then after that it goes into specifics, including naming the people that did the analysis and trying to get a handle on what would be involved in actually trying to recall the types of cases that we're talking about. Right now, obviously, the commission is kind of in flux as to what we're doing and how we're approaching it. So this was kind of a fact-finding informational process that the labs were cooperating with, and I think that's kind of where it's at.
Forgive me, I'm self-conscious about talking so much, but it's just one of those days, isn't it? Peter expresses his regret that he is in Montana and unable to be present for this. I know, Brian, that you had some discussions with Lynn Garcia and I heard that. And the analysts.
Someone just wanted to know if he was elk hunting. Come on.
Yeah. I'm going to tell him. In Texas, and our suggestion is that in Texas, they obviously the costs that have been calculated here for this comparison are extremely high. But what they found in Texas is they went back and they asked each of the labs that were engaged in microscopic hair comparison to pull 10 cases for each decade that they had worked. And they were able to get those and also got some volunteers and did some electronic legal research in terms of trying to find cases where there had been hair examiners and identified the hair examiners. And they found that they could do this initial survey for $50,000. So our suggestion back to the subgroup and the commission as a whole is that we try to replicate the process that they followed in Texas and ask labs if they can pull cases 10 per decade. There also, I think, may be people at the John Jay School of Criminal Justice or people upstate involved in criminology work who could be used as volunteers to assist the labs in reviewing and pulling the cases. So those are some of the suggestions because they seem to be able to do this in Texas. And the only way I think to really get a good estimate is to actually go about trying to pull maybe 10 cases from each decade from the number of labs so we can get a better handle on how much this really is going to cost. Does that sound reasonable?
Any thoughts? Yeah.
Barry, can you remind us why we would want to do that? These are cases that are over and done with and settled?
Yes, because ASCLD itself and the FBI have all agreed that when you go back and you look at the testimony of many analysts that were doing microscopic hair comparison, that the statements that the analysts made to the juries were beyond the limits of science. and that they conveyed to the jury an exaggerated sense of how unlikely it is to have an association. So what we believe, and it's what's going on in Texas, and the Federal Bureau of Investigation is doing this, is that there is a duty to correct. And so we could be able to identify those set of cases where an analysis of the transcripts might lead one to the conclusion that there had been an overstatement with respect to the probative value of the hair association, and this in turn, if the hair can be found, it could be subjected to mitochondrial DNA testing, or a judgment could be made by the laboratory itself, or a district attorney's office, or anyone else, that there was a duty to correct. And that's what's going on nationwide, and at least in Texas, and we hope that we would be able to do at relatively little expense in the state of New York.
Just to clarify, when you say nationwide, Barry, it's Texas and the FBI are the only two places where any type of review is going on right now. Is that correct?
Well, Texas is the first state that I think has a formal process in place. The FBI, as you know, testified in cases all across the country. So when I say nationwide, I do mean that. They were called in and testified in various different state courts.
In terms of a review, the only places where any formal review is going on right now are Texas and the FBI. Is that correct?
Yeah. I think to the best of my knowledge, that's correct.
Right. Kathy, did you?
I think one of the points that you make, did you say pull 10 cases per decade? Is that what you said?
Yeah, 10 cases per decade for each of the different labs.
I think what the issue is for a lot of the labs is that the farther back we go, they don't have any way to identify those specific cases that were, some can't even identify if it was a hair case, let alone to be able to say it was hair comparison case. So what we're really asking these labs to do is open up, case files that are hard record files, open up every single case file to look at it to see if there was a hair comparison, and then obviously further from there. And I think no matter how you look at it, even if you're saying just to identify 10, I don't know how many case files people are going to have to look through to identify 10. So, and it's not, I think it is a big project, and I guess my side of it is, I don't see why we're working at it from to me this is the backside. We're saying, let's review thousands and thousands of cases to identify the hair cases. Is there some other way we can go about this where we're identifying issues that we know of, that there were issues with people that had hair used in testimony that was or wasn't a problem? Is there any other way because to me we're searching through all these big large amount of documents to find the one or two, as opposed to trying to find a way to look at those one or two. Is there another way we can do that rather than go through every file?
Yeah. I think what they've done in Texas, and what they're, obviously they have doing with the Bureau, is that you'll be able to identify, first of all, you do an electronic search of reported cases, and you can, do some searches for hair comparison and certain analysts. I think that there's a comparatively few people that were doing microscopic hair comparison in the various different labs. That's certainly proved to be the case in many jurisdictions. And then, yes, so the answer to your question is yes, we're very much looking to try to find a way to identify the cases more expeditiously, and nobody wants to open up every case file. That's crazy. And so the idea is that we'd be able to identify the analysts that were doing hair cases, and maybe identify electronically cases that might involve microscopic hair comparisons, and very simply, for each of these analysts or each of these labs, we would pull 10 cases per decade, just as a starting point to see how much it would cost, and what, if any, problems exist. Because if everybody in New York State is testifying in a way that is unimpeachable as compared to the FBI analysts, well, that's one thing, and everybody can be quite proud of it. On the other hand, if they're doing some of the same things that the FBI analysts did, which may well be the case because so many hair analysts, frankly, were trained by the FBI and went to Quantico for this kind of instruction, then we'll be able to find that out. So
I think the issue is that the records are not electronic. That's the point that we're saying. For most of the labs, there are no electronic records to identify which cases were worked by certain analysts, or let alone which cases were hair only. So the only way for them to identify them is to actually hand review every case. I think that's our issue. I think in Texas, at least when I used to work in Texas, I know the lab I worked in, the large state system, they did have an electronic system that went back really a very long time. It was sort of the prelims type thing. So maybe that's why they were able to do that. I don't know.
I think there is another, following up on Kathy's suggestion, rather than looking at the back end, is there a way we can look at the result end as opposed to the originating end? We could do a Westlaw search, and I think that was part of the process in Texas, if I'm not mistaken.
No, that's what I was suggesting. That's what I meant by electronic, Mike.
Okay. So that is another possibility, is we do a Westlaw search with the terms that they used in Texas. I think Brian has those terms. Right. See how many cases we get. Circulate. We can do that search. We can circulate the results of that search to the commission, see how large a pool that is, and then we can decide from there, given the size of the pool, what would be an appropriate request to the labs. So if that's something the commission thinks is a good starting point, we could certainly do that.
Yeah, I would just add in addition that Lynn Garcia from Texas, if you want, she would be available by phone right now, but probably given the hour and the crush of business, it might be better just to put her in touch with this hair committee, subcommittee. And I would just add that what we should attempt to do, and as you say, one part of it is Westlaw or electronic searches, because we're all on the same page. We want to find an expeditious way to identify the cases. I just suggest that we try to follow the processes they are using in Texas, including this notion of trying to find 10 cases from each decade, because they've gone about that and they report to us that they've been able to do that for their labs for $50,000. And so that may be a good way to go.
I think we've gotten a little different information. My understanding was that the 10 cases was more, that what they did was way more than $50,000. But in any event, what I would suggest as a starting point is that, the Office of Forensic Services and, with the Office of Legal Services will get the search terms that they used in Texas. Using those search terms, we'll run them through Westlaw for New York cases. We'll identify any New York cases that hit with regard to those search terms. We'll notify the commission, in terms of what the size of the, feedback we get is, what the cases are. And then as a commission, we can decide as a starting point with regard to those cases that hit on the same search terms they used in Texas, how do we want to go about reviewing those cases? Let's see what we find there before. I hear Dr. Corrado's point. We're asking the labs to do an awful lot. And as a starting point, to say start digging through your records to find 10 from a decade, I'd much rather start with the Westlaw where we know we're hitting on these terms and we know we're getting some relevant cases.
But my only amendment to that is that we simply have DCJS and the subcommittee consult with the people in Texas so we're all on the same page as to what is involved in pulling those 10 cases per decade. Because our information in discussing it with them is that it wasn't that onerous. And I don't think that you can get a full sense of how expensive or inexpensive a task is going to be until you actually make at least a first initial effort to find it. So I accept your suggestion. I only add to it, Mike, that we consult further with Texas about how they've pulled the cases from the lab to see if it's at all possible to do that in New York.
All right, so we certainly will. We've consulted with Texas and we'll continue to do that. But what I would suggest then is as a first step, we do the Westlaw search using the terms that they used in Texas. We identify New York State cases that hit on those search terms. We circulate to the commission, how many cases there are, what the names of the cases are, and then ask the subcommittee that we've formed to give us a recommendation at the next meeting as to how we should systematically start reviewing those cases that hit on those search terms.
Can you also include the examiner name in that information that's provided to us? Is that going to be easily available?
If it's in the case, we certainly can. The published opinions vary widely in terms of what they...
Might have the guy's name.
Yeah, but to the... Actually, we
And they
could...
could provide the cases to the county, and then
We'd
they
have
can
to
pull
have
the
the
cases.
transcript
Yeah.
to get that. But
Is there any way?
knowing who the prosecuting DA is and who the defense attorney is on each of those cases, which will be in the record.
The appellate, we'll get the DA because we'll know the county. We'll know the appellate attorney, which may or may not be the same as the trial attorney.
Only that my playing devil's advocate would be, we're hitting on the labs because that's who we have interaction with. It would seem to me as the defense attorney who should be raising the issue if he thinks that hair analysis was inappropriately used in a case.
Well, that's what I'm not saying what we do. I'm saying let's get the information. Let's give it to the subcommittee that we formed already, and let's ask the subcommittee to come back to us at the next meeting with a recommendation of how we attack that. And the recommendation may well be, let's notify the DA, let's notify the defense attorney, but we've set that subcommittee up. Let's let them look at the universe of cases, look at the cases, and give us a recommendation as to how we ought to attack those cases. And then depending on what we find there, I think we could make some decisions as to what's reasonable after that. And Barry, we certainly will continue to consult with Texas, in terms of keeping up on what they're doing and what it's costing them and what the results are.
Yeah, one point about that as well, and maybe Dr. Corrado can fill us in on this. It's my understanding that for the various different decades, it might not be too difficult to identify the names of the analysts from various different laboratories who actually were the ones that were doing the microscopic hair comparison. I think Catherine Levine, may actually have the best institutional knowledge of all of that.
I think it's already in the survey. You asked the labs to provide the names, and we did. So all that information is already given to us.
Okay. So if the names are in the survey, that can assist electronic search. Okay.
There's a summary table that has that in the front. If you look at the bottom of the summary table, it has the names of examiners that were doing hair analysis in New York State.
All right, do we have a motion to do a Westlaw search using the search terms that Texas used, get the cases, we'll refer the cases to the subcommittee that we formed and ask the subcommittee to give us a recommendation as to how we go about reviewing those cases.
So moved.
And that we will further continue our consultation with Texas, and the subcommittee will, so that we can take suggestions from them on how they're proceeding and getting some results.
Agreed.
Absolutely.
So
All
moved.
right, we have a motion. Do we have a second?
Second.
All right, all in favor?
Aye.
Anybody opposed? Any abstentions?
Just clarifying, that was unanimous, right? Because I couldn't see hands, they were moving it a little stink.
That's the second time we've agreed, Barry.
Yeah.
No. So far, as I told you, we've agreed all day.
All right.
And I think we'll do that to the very end.
I'm getting a little nervous here. I don't know. All right, the next issue we have is an update. And again, let me just, before we move on, I know Brian's unit and the labs did a lot of work in terms of the hair comparison survey, again, on top of everything else. And thank you both for the work that you've done so far on that. The next issue we have is an update with regard to the Latent-Print survey that we've asked for. Brian, if you can start.
Right. So essentially at the last commission meeting, there was a motion put forward to try to quantify exactly where latent prints are in the state of New York. So you saw me screaming a little bit when we tried to have this done for the next meeting. And the reason is because there's 590 law enforcement agencies in the state of New York. And in order to do that, we have to go through and get through all those agencies. So let me kind of explain the process that I used. So what we did is, using a phone bank, we actually reached out to every one of those 590 law enforcement agencies with an initial inquiry of, do you perform latent print comparisons? And often what happens with phone inquiries is even after you're directed to people that theoretically should know, they don't quite know what you're talking about. So from that initial part of going through those 590 agencies, we were able to identify 125 agencies that potentially did latent prints. And we tried to be more inclusive. So if there was the potential for them to do latent prints, we put them into the inclusion. So those 125 agencies we actually sent paper surveys to. And the reason everyone didn't get surveys too is it would just be too onerous for us to track, and you'd get a lot of data back and it would just become lost. So based on that, the 125 that we've reached out to, we received approximately 75% response back compliance. And again, we have some summary tables. What we did is we included in the front of your binder, and also I think it's in your other binder, just what was sent to the law enforcement agency, so you can see a type of letter. So we actually addressed a letter to every single law enforcement agency that was part of the 125 identified. Then there was actually a survey, and that survey was sent back to one of the Office of Forensic Services staff. Then in the front of that, we actually have a summation table. So what happened is when you see no's here, this doesn't mean the person said no to the initial phone. This said that the person said yes to the initial phone. We sent the survey, and then someone who actually had to sign their name by it said, oh, no, we don't do that. So that's okay. But what it did is it narrowed it down. And then what happened is there's another summary table that comes down a little further, which actually talks about each jurisdiction and the amount of work they do and relatively the training they do. And behind is also the ones that responded positively. We actually have those surveys. We didn't include the negative ones because that's captured in the first table just to try and save some trees in this entire process. So what happened is as you go through and look at this document, the summary table up front captures what is actually present in all the different latent print surveys. There's individual ones that you can look at if you want to see actually who was representing that agency and what they were signing and what they were saying. So that's the process. This is the data. That's kind of it.
All right, comments or questions with regard to this item?
Do you really think Syracuse did 150,000?
Mr. Chairman, I'm not going to sit here while Commissioner Willie slanders the Syracuse. I want to point out to my fellow commissioners, and is the Inspector General still here? Yes. Inspector General, I think this should be a subject of inquiry for you, ma'am. Not for my department, but for every other department in the state of New York. If you'll notice, the Syracuse Police Department's 5 examiners, some of whom are part-time workers, managed to compare 60% of the fingerprints in the state of New York. If you do the math, it comes out to approximately 120 examinations per working day by each examiner. Now, the fact that we have 4,000 felonies in Onondaga County every year, most of whom are in the city of Syracuse, should not cause anyone to suggest that my department's hierarchy and leadership does not take this commission seriously or their responsibility after the Inspector General's report.
What do they do, counting each finger?
I think they counted each loop and whirl.
What I wondered is, if they're making value determinations, were they counting every value determination they made as a comparison?
Every point on each of
No, I
10
mean, every
fingers?
time they made
Yeah,
a decision if something was of value or not of value, as opposed to actually comparing it to a known print.
We don't have 130 or 149,000 cases a year.
You haven't even lifted that many latents a year?
Oh, they're taking them in from Texas.
From the other
You know what, I was actually curious whether Syracuse was doing the print analysis for other police departments.
Yes, the entire state of New Jersey.
I think for comparison purposes, it might be worthwhile of comparing the city of Syracuse, which I believe is 150,000.
Yeah.
Less than that, but close.
To the city of New York, which is approximately 8 million. And there are 45 examiners that did less work than the 5 part-time. But needless to say, I think
Slugs.
I just want to say that the documents were self-completed, so I don't testify to what I was received back in it.
Were they sworn to by any chance? No. I don't suppose, Mr. Chairman, you'll write a letter, requesting it. No, never mind.
No, it probably is a good idea that we follow up with them and just, let them know that their numbers were so far out of whack with the rest of the state.
How much do they get from DCJS every year? They might want to take their job a little more seriously. That's all I'm asking.
They get a fraction of what we give you.
Well, it should be. That's the way it should be. I actually read the Inspector General's report.
I move to give you more.
Thank you. Unbelievable.
But that said, I think this met the initial mandate, and I think now it's time for discussion on that to see. And clearly, there's more data we can get, and there's more data that's still coming in, as you saw from an email recently with a little bit more. But I kind of think there's enough information here to.
Yeah, in all seriousness, we will follow up with Syracuse. That's the only one that jumps out at me is being way out of line with everything else. So we'll follow up with the Syracuse Police Department and see if we can figure out, what's going on. And if there's a more accurate number, if there's a mistake in terms of what we're asking for, we'll try and clarify that. Any other discussion, conversation?
Well, then isn't the question to these entities which are not labs accredited under this commission, and it's voluntary, I mean, they voluntarily provided you with this information, to ask what are the credentials and training of the persons conducting their analysis?
It's part of the
It's already
survey.
captured.
Well, yeah, we did to some extent.
Well, to some extent, but, but wasn't that sort of the point? What do they know? What don't they know? How are they doing this? What do their reports look like? Are they aware?
I think the ultimate goal.
We can't force them to be accredited unless we get a legislative change.
Right. I think the ultimate goal, from my perspective, and I don't know if anyone else shares this, but you're exactly right. It would have to be probably an amendment to the executive law to include the discipline of fingerprint analysis under our jurisdiction. And that's something I'm very much in favor of.
But
Yeah,
short
it
of
struck me this morning, or not, earlier this afternoon, we heard Yonkers say that they develop fingerprints as an accredited lab, but then they send them to a police department, which I don't believe is accredited, to actually do the comparisons.
Right, and that's what the NYPD does as well. So the development is part of the accredited lab, and the comparison is part of the non-accredited entity.
which,
And then- I think that was the point of doing this survey, and I really commend to your attention that most of the research money that so far the National Institute of Standards and Technology and NIJ and NSF is devoting to basic and applied research in forensic science is going into fingerprints. And, the actual false negative and false positive rates for fingerprints are quite significant. And the new methodology that's being employed in terms of cognitive bias and trying to avoid it is very significant. And the continued use and expansion of the APHIS system is very significant. And I subscribe to what Bill Fitzpatrick said. This is one of the most important and valuable methods we have for identifying people who commit crimes and protecting those who didn't from being arrested for them. And it's not being taken advantage of, and there's an enormous amount of scientific activity and change going on in this field. And I wholly subscribe with what Bill said. We have to change the executive law. We have to have jurisdiction over those who are performing fingerprint analysis. And we have to put, frankly, some significant resources into making sure that this is all done correctly. And this is proceeding apace. It's going to be, in all likelihood, one of the very first disciplines that the National Commission on Forensic Science seriously undertakes. So I think it's a good thing we did this survey. I thought that was the point of doing this survey. And frankly, I hope there's a sense of the commission, we could even take a vote, is that we really do need to recommend to the legislature that they change the executive law and we get jurisdiction and force people doing fingerprint comparisons to be accredited and meet proper standards.
Yeah, and I was just asking, is it within our purview or our charge, to make recommendations like that?
Well, we discussed familial searching forever, and I've actually, independent of the commission, I've actually submitted a bill regarding familial searching, and Barry participated in drafting it. So I don't know. I don't know the answer to that. Have we ever
We haven't, but we can
recommend?
certainly make a recommendation.
I mean, what strikes me is we have 202 people that are performing latent print comparisons. We have no idea what their training is, no idea of their competency, no idea they may or may not take proficiency tests. We don't know the results of those tests. I mean, I think we do need to take some action.
I would recommend that we take a vote that it's the sense of the commission that the executive law be amended and that this commission has jurisdiction over fingerprint, those performing fingerprint identifications, comparisons, so that we can move towards getting these analysts accredited.
Seconded.
Hey, Barry, would this be something you'd be amenable to? How about the prosecutors, defense lawyers, and with the assistance of staff, try to draft a statute that we all agree on, and then present it at the next meeting, and vote on that, and then submit that bill to the legislature?
I'm fine with that.
Because I think there's things that need to be considered about how you'd phase this in. You can't just wave a wand and say you have to be accredited tomorrow. There has to be a phased implementation plan to take people and get them from 0 to 60 and see where that goes.
I guess I would just say, I didn't hear us say we're going to mandate accreditation yet. We're saying put them under the purview of the commission. Does that automatically?
Well,
We can't.
We don't
because
have the
executive law
authority to do it.
exempts them out.
But I mean, I'm sorry, if we change the executive law,
Then
we
they
say
would be
they're
within
under the purview of the commission, is that the same as saying they must be accredited?
Yes. So if they're not exempted out, they're in.
Just to be clear, though, we can't change it. The legislature would have to make the change. The governor would have to.
And that's all in the drafting. I mean,
Right.
coming up with what's that language going to say, so it's clear.
Do we
that
have-
they would have to be accredited.
Do we have a subcommittee, or I don't know if we're allowed to have subcommittees, but do we have a group that we've charged with working on this issue yet?
I don't believe
Well,
so.
I actually moved, maybe I can make some progress. I moved last meeting to have such a group, and I lost 5 votes to 6.
But
I'm going to move through it
Can I
again.
leave? I must have left.
And as a friendly to
is there a
Bill's proposal
volunteer that wants to take the lead in terms of, coming up with a draft for us to look at next meeting?
Yeah, I would, if Barry would assist.
Barry?
Yeah, I would definitely do that. And Marvin would help, I'm sure.
If Barry would assist, that's fine. Oh, and Marvin too, yeah.
All right, so then do we agree that we will, I don't think we need to take a vote, because there's no, but you and,
Yeah, we'll.
You and Barry
I'm
will
gonna-
work together.
I'm certainly going to deal with Brian and Gina
All right,
and
and we'll-
Dr. Corrado, and anybody else that wants to, get their 2 cents in, get a hold of me, Marvin or Barry.
so this will be on the next commission
Judge
meeting
Murphy,
agenda under old business.
Yeah.
Hopefully, at that point, we'll have something to look at in terms of a legislative recommendation. Anything else on this issue? All right, new business. Our first
Before
item.
we go to new business, Mike, can we come back to one of the tabs that we learned before that
Absolutely. Yes, I believe that was the first tab under old business, maybe? No, it wasn't. It
It's the
was-
measurement.
No, it was the,
Yeah, the MUMT compliance.
Oh, I was okay.
right. Yeah, ASCLD lab policy on measurement uncertainty. A 9-page document is the first document under that tab. And I direct the attention of the commission to page 5 of that first document. And to the bottom of the page, number 5, entitled Reporting Requirements. The applicable requirements in ISO 17025 regarding reported estimated measurement uncertainty are, and it refers to 5.10.3.1, test reports shall, where necessary for the interpretation of the test results, include the following. C, where applicable, a statement of the estimated uncertainty of measurement, semicolon. Information on uncertainty is needed in test reports when it is relevant to the validity or application of the test results, when a customer's instructions so require, or when the uncertainty affects compliance to a specification limit. The question that I asked earlier was, is there an agreement, or do we know if any of the labs in New York State have an agreement requested by a customer, particularly law enforcement, either a DA's office or a police unit, that asks them not to report the measurement of uncertainty in the final lab report? Brian at that point asked for me to direct him to a document. The document that I'm referring to is entitled Askeladd Lab International Guidance on the Estimation of Measurement Uncertainty, Annex A, details on the NIST 8-step process. That is not in our manual or in this agenda book. The report that I'm referring to the best of my knowledge, this underlying document, which is still in effect, and I may be wrong, maybe it was repealed, but I don't think so. On page 18 out of 21 pages of that document, there's a section called Reports of Uncertainty, and it says the following. For certain testing applications, the laboratory, and this refers, by the way, this section is to measurement uncertainty. For certain testing applications, the laboratory may have an agreement with the appropriate legal or judicial customers that estimated uncertainty is not required in a test report unless the measurement shall, parentheses, considering the expanded uncertainty, end paren, falls within a certain range around a legal specification. Such an arrangement is acceptable to Askeladd Lab as long as the agreement with the appropriate customers is in writing, is readily available for review in the laboratory, and is scientifically/mathematically reasonable. The existence of such a written agreement to limit the testing laboratory's reporting of measurement uncertainty does not excuse the lab from estimating the measurement uncertainty of the test method. So my question remains. There's a policy now in effect as of December 31st, 2013 that requires every lab that is ISO accredited to have and calculate the measurement of uncertainty. The particular arrangement allows a laboratory at the request of a police or law enforcement agency.
You don't have to do it if it's nowhere near the charge. Just responding to this, Marvin. I think I understand your question and what you're asking now.
Brian, I'm not finished yet.
Okay.
The point that I'm making on page 5 of the current Askeladd Lab policy alludes to the fact when a customer's instruction so requires. So it seems that while measurement of uncertainty now must be calculated, that the final report that is given to a defense attorney, prosecutor, judge, if there's a private agreement, may not include the measurement of uncertainty. Now, the answer to that is that in all likelihood, although it is not a certainty, that the measurement of uncertainty is in the case file, although that's not a given. I don't know that labs do that since December 31st, 2013. The issue for me is, do we currently know if any of the 19 labs under our jurisdiction have any such private agreements with law enforcement or any customer not to report measurements of uncertainty? If the answer is yes, we know, then we'd like to know it. If the answer is we don't know, then I think we ought to inquire. A simple letter from the chair of the commission to the labs asking that would tell us the answer very quickly.
Just, Marvin, I think that you're misreading, in my opinion, or misinterpreting requirement number 5. I don't see anywhere in there where it says that a lab can have an agreement that allows them not to report. 5C is saying there are 3 scenarios under which measurement uncertainty must be in the report. One of those is where the customer's instruction requires it. There's 2 others. There's nowhere in there that says or authorizes them to make an agreement to leave it out. And every one of our labs has certified to us that they are complying with this requirement. So it seems to me that by definition that answers your inquiry.
The part that you're leaving out in that narrow interpretation is that while the specific requirement number 5 says when a customer's instruction so requires, leaves open the other possibility that when a customer's instruction does not require or instructs you not to do it. And while all of the labs have now said to us that they are complying by calculating a measurement of uncertainty, it appears that Askeladd Lab, in its guidance on the estimation of measurement uncertainty, a document still in effect, that they are saying if you have such a written agreement and you can show it to us, then you don't have to print out the measurement of uncertainty. So your answer, Mike, doesn't quite cover the problem.
And I disagree with you there, Marvin.
Policy in one document says one thing,
You're not,
and the policy in the document says
that other
something
document
else.
has nothing to do with it. We have a policy here on measurement uncertainty. And regardless of what else is out there, every lab has certified to us that they're following this particular policy right here. And even if they had those agreements, I'm not aware of any lab that has one, but even if they had them, they are still certifying to us that under 5C, where applicable, and it gives the conditions where information on uncertainty is needed in test reports, when it's relevant to the validity or application of the test result, when the customer's instruction requires it, or when the uncertainty affects the compliance to a specification limit, they're certifying to us that they're including it in their reports. So it seems to me that answers your question. They've all signed a certification telling us, regardless of what agreements they have or don't have, they're putting it in the reports when it meets any of those requirements.
So currently, it's your understanding that measurement of uncertainty as of December 31st, 2000, that it is in the final report, we will see a measurement of uncertainty calculated on the page or the final report pages indicating that?
I guess I don't know where the reference to 2000 comes from.
Did you say the guidance documents you're reading, what is the date on them?
Guidance document is dated effective July 1st, 2012. Copyrighted 2011.
I honestly, I remember that. I remember the statement you're talking about, and I really can't remember if there's a new one. I think what that was talking about was there was an exception that you could, if you had an agreement that instead of putting it on every report, you would maybe just put it on measurements that were close to a legal threshold, let's say. So if you had an agreement that I'm not going to put uncertainty on things that are so well above the legal limit that it's not relevant, I'm only going to put it on measurements that are close to the legal requirement. I think it maybe allowed you to do that. I don't honestly know if that's still in effect or not. I don't remember. I don't remember the latest date of the revision, but I think what Chairman Green is saying is correct in that these are the requirements that it's on the report. I think if, you know, if it would help, I don't think it's a problem for the labs to indicate whether or not they're putting the measurement uncertainty on their reports. I mean, we could certainly answer that question.
Could you bring that up at your next meeting and find out if that's being done, or if even if there is some indication on the final lab report that measurement of uncertainty has been calculated and it can be found in the case file?
Yes, I can ask that question.
Well, we do note that the policy that's included in the book is dated as effective May 2013, and it says it replaces the previous document.
Yes, I agree, but what his document is a guidance, and this is actually the standard. And I do believe, I think they instituted new guidance documents as well, and I don't recall if that is still in that document or not. But I can certainly, through NICLAC, we can just pull the labs and see. I can tell you, you know, for instance, I know my lab, we put it on our reports, and I believe the majority of labs do, you know, but we can certainly ask about that.
Since we've come back to this tab, just an interesting comment. All the labs certified that they comply with this requirement. It is only applicable to quantitative lab measurements. But I would point out that New York City Office of Chief Medical Examiners said the reason they don't comply is because we do not report any measurements that matter. That's a quote. Now, he could have said we don't report any measurements that are quantitative, and therefore it does not apply. But he said nothing he reports matters.
I think I can clarify that statement. I'm sorry to interrupt. I think initially when the instruction from ASCLD Lab was coming out, they talked about measurements that matter, meaning measurements that are close to a legal charge. So that was kind of a terminology. And I agree that, having 2 Asperger's children, that it's a little Aspergian to use that exact term in there. But I think the intent was not malicious. The intent was to say specifically responding to the standard. But the DNA subcommittee was equally bristled by the language of it. And they talked about it. But I think, just to clarify, if that gives you any solace.
I mean, I think it goes to the earlier comments about this is a laboratory that, under its current director, has not acknowledged that others have some authority over what they do. And so, to say what he does doesn't matter. Okay. But I just thought that was very strange.
All right, is that everything with regard to that item? All right, the next, I think that takes us to new business now. The first item listed under new business was John Neuter, the Executive Director of ASCLD Lab. He wanted to come and introduce himself to the commission, and talk with the commission for a few minutes, but it's my understanding that he could not make it today. Is that correct?
I apologize for that. I kind of encouraged him not to, looking at the agenda and thinking that we had a lot of stuff to cover. So he's actually going to join us for the June meeting. But I did want to encourage him and didn't think we thought less of him, but just looking at the robust agenda we had, I encouraged him to come for the next agenda to talk when we met again in June.
All right, the next item we have are the annual lab summaries. They are provided annually to the commission members. They're here in the binders. I don't know that there's any need for any discussion, but certainly if anyone has anything they want to say with regard to those, they're welcome to. All right, if there's nothing on the annual lab summaries, the next item we have is an item with regard to low copy number DNA testing. This item is put on the agenda at the request of Commission Member Scheck. So Barry, the floor is yours.
Yes. Well, what I think everybody has is a binder of the email traffic and attachments that went to the various different commission members and members of the DNA subcommittee with respect to this issue. And the first thing that I'd like to say, and I think that I hope, Mike, that there's some general agreement about this, and that is that even though this case came to our attention when the parties to a federal criminal case involving a defendant named Johnny Morgan began issuing subpoenas to the commission for production of documents and to first myself individually and then Peter Neufeld. And Mike, how many subpoenas did you and Brian receive? No?
I received one, and we had 2 for records.
I believe we had 1 personal subpoena and 2 subpoenas for records.
Right. And so what I think happened during the course of this is that when we all got the subpoenas, email traffic went back and forth as I guess the government had taken the position initially in this case that there was no need for a Daubert hearing because the DNA Commission and the subcommittee had already approved the use of low copy number DNA testing. And the judge then proceeded to a hearing, but obviously, as you all saw for the correspondence, issues arose with respect to the commission deliberation and representations made to the commission and quote-unquote understandings about whether or not there was a 20 picogram limit for the use of low copy number DNA in casework type samples. And as the emails and the record exchanged back and forth, and I realized that they were voluminous and the issue arose eventually, I think, to the point of being something that we as the commission and the DNA subcommittee had to address because, and that it was just based on my reading of the record, is that it did seem to me that Dr. Prince had made representations to the DNA subcommittee and ultimately the commission during discussions that low copy number DNA testing on casework samples would not go below 20 picograms. And for those of you that are not altogether familiar with this, low copy number DNA testing involves the use of extra cycles. It's a technique that I believe only the Office of Chief Medical Examiner at this point, arguably maybe the British, use. And it has not been adopted or used by other laboratories. And I really think it's important that we view this as a matter of commission process and scientific process and not be concerned and not try to be answering questions on the timetable of a court or any particular litigated proceeding. I think that's where we've had a problem here. But my reading of the record is that there were representations made to us that the OCME would only be doing low copy number testing with these extra cycles on casework samples and mixtures, things that come from crime scenes that were 20 picograms and not below that. The discussion that was had at the General Commission meeting when the recommendation about low copy number DNA testing came back, there was a motion by Peter Neufeld and Dr. Jenny that there be proficiency testing at the 20 picogram validated limit. That motion was defeated, but Chauncey Parker subsequently sent a letter back to the DNA subcommittee. And Mike, for your edification, it was included in my very first email in the voluminous supplement, right? But
Thank
it's
you
an
for
email that I
edifying me,
included.
Perry.
No, I wasn't expecting anybody who wasn't, going through the entire record to see it, but it's a letter that did go out where he does refer to the validated minimum template amount of 20 picograms. And I just did receive from Brian this morning some additional records here of some subsequent commission proceedings where there was a report back about the issue of ongoing monitoring of OCME and the low copy number testing and the issue of proficiency testing. And at page 54 and 55 of that commission proceeding again, there are references. Mr. Neufeld asks Dr. Prinz, are you having any problems with cases that are at the threshold of 20, it says here micrograms, but it means picograms. She says, what do you mean? Well, I think you reported last time that was the threshold for a low copy, right? And she answers, right. So I think when you look at and I realize that people may not have had a chance to study all the recent submissions, but as you can see from my last email, I believe that it is clear that in terms of SWGDAM guidelines and national standards and as John Butler has pointed out, that when you have a new technique such as low copy number DNA, particularly when you're dealing with these very small amounts, that it's one thing to do a proficiency test, a validation study on Buccal swabs, which I believe in the published low copy number article by Dr. Karajin and her colleagues that was, I think, published in 2009, but presumably was the basis for the original report to the Commission in 2005. They took Buccal swabs of mixtures of two individuals and did testing at 150 and 25 picograms. They came before the Commission in 2005, 2006, and said that they were going to do it on casework samples at 20 picograms, but in their own testing, they didn't feel it was reliable to go below 20 picograms. That was the way I read the record as to their representations. The one thing I will point out, and I think that this is just a fact in terms of standards, and that is that the national standard is that even though you may do validation studies initially on buccal swabs or clean samples, so to speak, there must be an internal validation or a set of validation studies where you actually do tests on casework samples, such as the one involved in the Morgan case, which is swabbing a gun from casework type samples where you can demonstrate that you get reliable results at some particular threshold. And I think that the record as I read it is that the commission and the DNA subcommittee was being told by OCME that they could reliably do testing at 20 picograms with low copy number testing. And the suggestion was merely being made that they ought to proficiency test at that level. It's now our understanding, because we got dragged into this Morgan case, where there was apparently testing done at 14 picograms involving mixtures of 3 individuals, as to whether or not, and apparently at some point in my reading of the record from the Morgan case, it was in 2010 or 2011, that the protocol changed, and with the supervisor's permission, you could go below 20 picograms. So I'm just concerned about this because this is an area that, as I've been pointing out to all of you colleagues, there is tremendous concern in the forensic DNA community about dealing with low template DNA and pushing this technology beyond its proper validated limits. And as I pointed out in our last meeting, when it comes to disaggregating mixtures and doing statistical calculations, we have true allele, armed expert, lab retriever, and the forensic statistical tool at OCME, and they can all give you different results. So my proposal, very simply, is first, I would like to make a request of OCME that they produce for this commission and in the first instance the DNA subcommittee any internal validation studies they have showing that they have in fact tested low copy DNA methodology on samples below 20 picograms to demonstrate that they can do it reliably, that they produce that for the DNA subcommittee, they produce it for the commission, and that the DNA subcommittee also reports back to us on this whole question of whether low copy number DNA testing can reliably be done or has been reliably validated on samples below 20 picograms. Obviously, you know, that would require some going through all of these materials and any other materials that OCME could produce for the DNA subcommittee, and they could report back to us on this issue. And I think that that would be the best way for us to get to the question about the validity of this kind of testing, and hopefully we could agree upon that. And what I really don't want to do, even though our email traffic back and forth was filled with it, is get into any kind of discussion that's in any way ad hominem, personal, or making judgments about anybody else. I just want to deal with this issue scientifically, so that's my proposal.
And I guess one thing I think is important is that the commission members have a full understanding of the actions taken, and the correspondence that I've seen back and forth stopped with the December 14th, 2005 letter that you referenced from Chauncey Parker. I don't know if it stopped there because that's all the defense attorney gave you, or if it stopped there because that's where you stopped. But that's not the entire picture of what happened. When this was looked at, prior to that, the DNA subcommittee explored what OCME was doing, wrote a binding recommendation to the commission recommending that OCME be allowed to do this testing. There was no mention of any limit in the letter. The commission then accepted that binding recommendation, and then, as you correctly point out, I think on a motion by D.A. Fitzpatrick, Chauncey Parker wrote the December 14th, 2005 letter back to the subcommission based on some concerns that the commission had expressed. The subcommission then requested and or received additional information from OCME. One of those additional pieces of information was a memo dated August 21st of 2006, which is in the materials that we provided to the commission shortly before the meeting. But in addition to that, there was a letter then from September 18th, 2006, from John Valentine, the chair of the subcommittee, back to Chauncey Parker as the commissioner. In that letter, John Valentine indicates that, first of all, his letter is in response to Chauncey Parker's December 14th letter. He goes on to indicate that the subcommittee reviewed the issues outlined in the December 14th letter at its meeting of August 22nd, 2006, and discussed quality control procedures for monitoring and documenting the performance of this method in the analysis of casework evidence. These procedures are described in the attached summary, which was provided to the subcommittee by the New York City OCME representatives in attendance at the meeting, which I'm being told is the August 21st, 2006 memo. And then he goes on to say, the subcommittee's review found the procedures described in the attachment as reasonable and appropriate to ensure reliable results with this method, and voted unanimously to make this binding recommendation to the Commission on Forensic Science to approve these procedures. And again, I'm not an expert in this, Barry. I certainly don't have the expertise you do. But as I read this August 21st, 2006 memo from the OCME, it doesn't talk about a cutoff at 25. It talks about cutoff levels or testing done at different levels, one with a 100 picogram cutoff, one with a 25 picogram cutoff, and one with a 6.25 picogram cutoff. So from my review of the record, that's what the DNA subcommittee approved. The DNA subcommittee sent a binding recommendation back to the commission. It was then discussed at the next commission meeting. And the commission never undid or never took back its recommendation. So from my review of the whole record, I don't see where this 20 picogram cutoff that you referred to, I see reference to it. But when you look at the whole record, I don't see anywhere where that is the finding or the vote or the decision. I see the decision as encompassed by these documents, which talk about testing as low as 6.25 picograms. So I don't know where we go, but I think you're asking that this go back for them to look at the validation and and it seems to me they've done that. I think this is what they were describing doing in their September 18th, 2006 letter.
Well, Mike, what...
I should note, too, Barry, that we sent, in response to the subpoena, that September 18th, 2006 letter was sent to the defense. So, I did find it puzzling that never made it into the attachments that were sent around, which I assume they were defense exhibits, as I understood from your email. So I did find it rather puzzling that we supplied both letters to the defense, and for some reason the one letter that could arguably be helpful to them was included, but the other one wasn't.
Well, I only was looking at the submissions to the court back and forth. I didn't see this, but let me just be very clear about this, Mike, because I do think that as a scientific matter, you may be misreading these facts. So let me just put forward what I think is the record, and we can agree to disagree about the interpretation. When you go back and look at the record, Dr. Prince, on I think at least 6 occasions in the discussion before the commission, talked about a 20 picogram limit and statements that it wouldn't be reliable to go below that. Then there was a discussion and a motion about doing proficiency testing at the 20 picogram level. That was defeated. However, on Bill's motion, Chauncey Parker sent a letter to the DNA subcommittee, presumably for OCME, saying, well, if you're not going to do proficiency testing at that level, at least assure us that you're going to be doing ongoing quality assurance and supervision of the low copy number testing, because everybody knows that this is was a new and frankly on the edge procedure that has a danger of producing with stochastic fluctuation artifacts. So everybody was concerned about that. Then they reported back, as you say, and even in this September 18th letter, the reason that I read from the November 9th, 2006 transcript where there was discussion between Dr. Prince and Mr. Neufeld at page 54 and 55, it's my contention when you go through the whole record, Mike, that the understanding was still that what OCME was doing was low copy number testing at 20 picograms as they had represented, and that that was the program that the DNA subcommittee was looking at, that for low copy number testing at a 20 picogram threshold, they were performing proper quality assurance, they were supervising, they were looking at it. Nowhere in this communication or looking at this record do I see anything that indicates that OCME had done the proper internal validation study on casework samples, demonstrating that they could do LCN testing on samples below 20 picograms. And indeed, at page 54 and 55 of the meeting of November 6th that you just sent to us, Dr. Prinz says to Mr. Neufeld that, yes, this is all being done at the 20 picogram level. So that's the issue. So I don't really think that in the final analysis, it's really for us at this point particularly useful, unless others have a different view of this record. I think that the sound policy is to ask OCME to produce for us. If they want to do it today, they can do it today. If they want to do it on another occasion, that's fine. I would like to see them produce for both the DNA subcommittee and us internal validation studies showing that they can reliably type with low copy number samples and mixtures below 20 picograms, that they have done that work, that they have produced that at some point. The reference you make to these August submissions, I only glanced through. I haven't had a chance to study, but I do not believe they constitute the kind of validation studies that John Butler and everybody else would require. And I'd ask for the wisdom of the DNA subcommittee as well in reviewing that and telling us as a commission whether OCME has done the proper validation, internal validation on casework samples such that they can type reliably at below 20 picograms. That's my motion.
I would just like to say a couple things. The first is that I'm not really looking at either side of it. In looking at the record, I did notice a few other statements that were made that maybe would clarify it. The first is that they did do validation from contact DNA from touched objects, and what they concluded from that was that their conclusion was samples amped with less than 20 picograms did not yield a high percentage of database eligible samples and will not be tested for non-suspect cases. To me, that implies they're not going to test them for non-suspect cases because they're not going to get enough loci to go into the database, but it implies they will test it for cases with suspects. Another validation they did when they were asked to look at their high sensitivity extraction method, they said that 6.25 picograms, 12.5 picograms are below the threshold for amplification for DNA databasing. So again, I think they were referring to, at least my interpretation is they may have been referring to what you're going to use for a database threshold. It's sort of not worth their resources to amp something if it's not going to meet the database threshold if there's no suspect. Now, besides for that, I mean, that I understand this can be debated. I'm not really trying to debate that. my issue is that the template amount to me is one part of it, and I think people are missing that a little bit. You could have 40 picograms of a mixture of 4 people, and that's going to be less useful than a 15 picogram sample that's just one person. So you never know, going into it with your template amount, you never know if there's a mixture, how many people are there. So to specify an exact template amount really, to me, isn't the main point. I think the point for me is, are there thresholds in their interpretation guidelines sufficient enough to allow them to analyze this data and make the proper conclusions? I mean, to me, that's what the validation, what you're looking at in your validation are, what are your interpretation guidelines? So, I feel a little bit like this template amount is being focused on, and I'm not sure that that's necessarily what the real question is.
Well, I don't disagree. I think that the issue is validation. I just point out to you, Dr. Corrado, that what's unique about low copy number DNA testing is it's my understanding that they divide the biological samples up 3 ways, right? And then they do testing of the 3 different samples, and when they get a congruence of alleles on 2 of the 3, then they make the calls. Now that's very different, I think, than other procedures. And as a consequence, it may be that the template amount has some relationship to the reliability of your results. I don't know. I just know one thing, and I know one thing very, very certainly, and that is, just as I put in my last email to you, that there has to be internal validation studies on casework samples that can demonstrate that you can do reliable testing at below 20 picograms on mixtures, right? That is what I believe is the national standard, has been for years, has been from the moment that we began litigating these DNA cases, which frankly led to the formation of this commission. Now, it may well be that the Office of Chief Medical Examiner, which as I understand it from the record, has actually only changed its protocol to do typing below 20 picograms as late as 2010, 2011. But the point is, on casework, the point is that we should have a clear statement from the DNA subcommittee, from OCME, so that we can be satisfied and the subcommittee can be satisfied that they have in fact done the proper internal validation and they can reliably use this technique that no one else in the country is using on samples that are below 20 picograms. That to me seems to, as a matter of commission process, and just to be assured that this is being done reliably, what should happen. And that's why my motion is to get those, get the OCME to produce that validation for us, produce it for the DNA subcommittee, and have the DNA subcommittee review this and report back to us as to whether this is properly validated, and remove any ambiguity about what this record means or doesn't mean.
Barry, isn't there something in the materials you provided us today from OCME dated April 2005, where they outline the testing protocols and they talk about testing between 4 and 20 picograms, then testing between 20.5 and 100 picograms, and then testing over 100 picograms?
What are you referring to, Mike?
You didn't put page numbers on what you sent us, but it's under
Which tab?
Which
maybe
tab?
15 pages. It's I guess the nearest tab I can find would be tab 2.
Tab 2 is the
Because that's the, I think they use.
That's the legal record.
Tab 2 of the is the record from the Morgan case that I produced for you in the first instance. So there are a number of submissions there. If you could refer me to a section of the page, that would be helpful.
There is no page. It says draft, identifier 31 cycle amplification, OCME, NYC, Department of Forensic Biology, April 2005.
I mean, well, are you talking about some of these charts or ladders? You know,
I know it's crazy, but.
No, just,
Mike, my proposal to you is, which I hope we can all agree on, is rather than just looking through some of these submissions where these and finding doesn't something here refer to something that's below 20 picograms? I think the best thing from a scientific matter is to refer this back to the people that are supposed to be doing this analysis for us to make sure that the proper validation was done. I think that when you just look at the record of what they represented, what Dr. Prins represented, I think it's clear from all the way through the last set of submissions that you just gave us that there was an understanding or a representation that there was a 20 picogram validated limit to low copy number testing. And my question is very simply, I'd like to see the internal validation studies that they can do it below 20 picograms on casework samples, which I think is the national standard. Certainly, I gave you the references that John Butler says. Maybe I'm wrong about that. Let the DNA subcommittee tell us. I don't think I'm wrong about the necessity for that. And let the DNA subcommittee tell us more about exactly what, if anything, they've reviewed or what OCME can now show them that shows that they can reliably type this below 20 picograms. And then I think we've fulfilled our function.
I guess I have a different view of it. I think that the commission has already twice sent this to the DNA subcommittee. I think the DNA subcommittee's twice looked at it, and both times sent it back to the commission with binding recommendations with no reference to a limit. So I don't know what we'd be asking them to do that they haven't done already. But again, we have different interpretations. So I don't want to take any more time. If you've got a motion, if other people want to discuss it, great. And if not, we'll just, if there's a second, we'll vote on it.
Yeah, my motion very simply is that we remand this to the DNA subcommittee for them to report back to us about whether the Office of Chief Medical Examiner has properly validated the use of low copy number DNA testing below 20 picograms. And I would additionally move that OCME produce for the DNA subcommittee and for this commission all valid internal validation studies or any kind of validation study that justifies doing it below a 20 picogram level. Now, you and I can disagree about what a letter says back and forth, but I think that we disagree about what was said and what was. I don't think we've ever gotten a clear statement from the DNA subcommittee on whether they can reliably do this below 20 picograms. I don't read the record that way. I don't see anything in the record that states that clearly, Mike. And certainly Chauncey Parker's letter, where he refers this back to the validated minimum of 20 picograms, certainly makes this at the very least ambiguous. And so my point to you is it's the better part of wisdom on a matter of this kind of importance, because we're dealing here with I hope it's not many cases that they did low copy number testing below 20 picograms. I don't think it's necessarily hundreds of cases by any means. But if it hasn't been properly validated, we need to know about it. And I certainly think that it can do us no harm to have the DNA subcommittee review it. If, as you say, they already reviewed testing below 20 picograms with low copy number, and it's all great, and it's been properly validated in their view, why not have them tell us that? So that's my motion.
Any other discussion?
I have a couple of questions. Would Ocme have to have had to produce internal validation studies in the past to the DNA subcommittee before they sent us that binding recommendation?
Yes. It's my understanding, yes, that the DNA subcommittee would not have sent the recommendation without it.
So they have to exist somewhere.
Yeah.
Right. Do we know if any of those had to do with lower than 20 picogram thresholds?
No. Well,
We don't know.
I mean, I'm just saying the validations that you see, some of them, they're doing sensitivity studies. They are going below 20 picograms in their validation studies.
The method that's described says down to 6.2.
Right. I mean, their QA was down to 6. They're doing that quarterly.
And just a quick question to Barry, if you know, was that issue about the validation studies addressed at the Daubert hearing in the Morgan case?
Yeah,
And then I'll tell you why I'm asking it. Just if you know, yes or no. Not cross-examining you. I just want to know. I just want to get the hell out of here before 7. What was it?
Bring it up.
I'm not sure I understand your question.
When at the Daubert hearing, did they challenged the scientific validity of this?
Right.
And did they? And when I assume somebody from Ocme testified.
Yeah.
And did they cross-examine him or her about, do you have validation studies or?
I mean, the issue of validation studies was discussed back and forth. You know, the problem is that ultimately that's going to be for the judge to determine.
Right.
I saw nothing produced in the record showing that there was an appropriate internal validation study demonstrating that they could do testing on samples below 20 picograms. Nothing that I would recognize as a validation study on casework. Now, maybe there was, as you point out, Bill, something produced to the DNA subcommittee that of that nature. Or maybe the DNA subcommittee feels that they don't need to have validation studies of that nature, and if that's the case, then they'll so tell us.
Okay, here's my thoughts on this. First of all, I want the motion to be streamlined a little bit because Barry made it compound, I think, a couple of times. But I reviewed this, and when I first reviewed it, I didn't have the response to the motion that I made back then. I got that, I think, this morning. I also didn't have Kathy's analysis of what you believe Becky Prince meant when she said.
I don't know that.
No, I know. I understand. I understand. No, it makes sense to me because to say a 20 picogram threshold is a limit doesn't make sense to me because you could be talking about 3 people. So you're talking about, 6.6, 6.6, and 6.6. But in fairness, as you read the record, you can make the argument that she said it's a 20 picogram threshold. I mean, I understand Barry's point. Is there a downside to sending this to the DNA subcommittee and say, look, would you tell us crystal clear, are you validating this, which is a binding recommendation on us, are you validating the science of this procedure regardless of the threshold? Or are you saying that there needs to be some type of threshold? I mean, is there a downside to that? Understanding that we're not doing a Daubert hearing, and the court in Brooklyn or in Manhattan is not doing an accreditation process.
I guess my issue is I don't know that we should be questioning the threshold. I feel like if the motion is to have the DNA subcommittee relook at the validation to make sure that they believe the validation was proper to allow them to make these calls, I'm okay with that because I think that's a fair thing to ask them to do.
Barry,
but to ask them to look at the
how is what Kathy said different from what you're asking? Or is it different?
I don't think it's different, but just to be more pointed, I mean, I'm perfectly okay if they're going to come back and say, we believe that this is validated and reliable to test below 20 picograms. All that I've been saying from the beginning is that the way I read the record is that they were telling us that it was a 20 picogram threshold. Now, whether that's sensible or not when you're talking about mixtures, and there may, I think there's some arguments that it is, why don't they just tell us that? So I'm fine with Kathy's motion that we remand it to them for us to tell us whether they believe that OCME is validated, has done the proper validation to say that they can test below 20 picograms. I mean, okay. I have no problem with that.
If that's a motion.
And can I add actually something? So I've been sitting here silently. I was actually a member of the subcommittee the year that this validation was discussed. I was not at the meeting where it was approved.
Just start.
So I don't want to rely on my memory, and I haven't had time to go back and find notes and look through them. So I don't want to do that. But I don't think throwing it back to the subcommittee and asking them to review it is a bad idea. And the additional component might be that they make sure that the procedure that they approved is still the one that's being used and that it hasn't been significantly modified by OCME in the intervening 9 years. And if it has been significantly modified, they may want to look at additional validation material to see that it still holds up.
One thing to just remember in this entire process is there is kind of a validation that we're ignoring. Excuse me. That's the validation that they're developing profiles, and these profiles are matching individuals that are in these cases, and I don't think it's a random coincidence that it's coming up with this person's profile. You know, I think there is a level of validation that occurs within casework, and they have done tremendous amount of casework, I imagine, in the 9 years looking at this. So I think it might just be there's some information sharing, but I want to be clear that at least in my opinion right now, there's nothing wrong with what they're doing. There might be some point down the future, who knows, but at this point, they were approved to do something, and they're doing it.
Yeah, I don't want to turn this into an effort to assist. I mean, this could be incredibly important for the Innocence Project. It could be, and it is incredibly important for prosecutors. And I wish I could go back to 2005 and say, excuse me, Dr. Prince, exactly what do you mean by that 20 picogram threshold? But out of fairness, in reading her repeated statements that, yes, we're only talking about a 20 picogram threshold, as long as this is not used as some vehicle to say, aha, see, Your Honor, this is junk. Even the Forensic Science Commission thinks it's junk. Because that's what, nobody's saying that in this room or in New York. So if I can, combining Barry and Commissioner Walsh's recommendation that we, if I may, Barry, fill in the blanks, that we refer this to the DNA subcommittee for the express purpose of determining, A, is there a picogram threshold that needs to be met before the science is valid? And B, this is incorporating Ann's point, since you reviewed this 9 years ago, are you considering any variations in the science, and has that science been validated as well? Is that fair?
Is it variations in the science, or you're talking about variations in the procedure?
I was actually talking about, so it's not uncommon for a lab to develop a procedure and write up a standard operating procedure, and then 3 or 4 years down the line, something changes, a reagent, a piece of equipment, they want to go lower on the volume.
So if I substitute the word procedure for science.
Standard operating procedure.
Standard operating procedures. So that would be, if Barry's gentlemanly enough to defer, that would be my motion.
I agree with that. And, I think Dr. Walsh, I think her assessment of what we need to find out is exactly the right one.
Do we have a motion?
So yeah.
Second.
Any other discussion? Yes.
Since we have the live representatives here, I was wondering if they would care to comment.
I didn't know they were there. Well, yeah, I didn't know they were there. Yeah. So does somebody want to come up?
Yes. Yeah, we've been talking like they're not here. Yeah, my question was, would you care to comment, because you guys are really involved with this. Would you care to comment before we vote?
Just say no.
No. They indicate for the record, no, they don't wish to comment.
Huh?
Who's there?
So just,
Barry, who's there?
I believe Mr. Kupperschmidt, Eugene Lean, Mimi Mayers, and it's Rosenberg.
All right, ask them for me why they don't want to comment. Never mind. That's the motion.
I'm sorry to be a pain, just because the person has to kind of quantify this. I've kind of lost track. It's moved in 6 directions.
Don't ask me to repeat it. And you repeat it. I can't remember.
If we can just come to an agreement about what it is so we can make sure we're on the right page.
Yeah, we're referring this matter to the DNA subcommittee to answer 2 questions. One, is there a threshold that must be met before this technique can be employed, this LCN technique? And 2, have the standard operating procedures changed in the 9 years since this procedure was validated? And if so, has there been sufficient validation to support the change in those standard operating procedures?
Friendly amendment, whatever you say.
I was going to amend it too, so go ahead.
The first one about, what was you said the
Is there a threshold that can be?
I think that's the wrong question. Threshold means a lot of different things in science. I'm not sure if you're meaning to say template amount, or is that the question?
Quantity
I don't know.
of DNA.
Quantity of input DNA.
Quantity of,
perhaps.
yeah, I mean, I didn't know before yesterday that a picogram is smaller than a nanogram, significantly smaller. So I accept that amendment.
I wonder about making a further amendment, and I apologize, but I just want to again clarify that as a precursor to this, that the Commission acknowledges that the OCME is allowed to perform low copy number testing and is requesting clarification about these. Because I don't want it again.
To that. That's not an amendment. That's a totally different motion. That's
I
like
don't
a
think-
rider in Congress.
I don't think
bill.
that's.
I object.
I don't think that's necessary, because
Okay.
if someone asked me now, I would say that based on the 2006 binding recommendation, that they're allowed to do it.
Right, but just again, and maybe because I'm the person that's always pulling documents for these subpoenas and pulling this out, I want to be absolutely clear that the Commission is not doing something that's questioning this. We're looking for clarification. So from the subcommittee,
Yes.
but this does not mean that there is a current problem that needs to be addressed. We're clarifying a point that has come up.
Well,
Yeah, because what's
Right,
happened
Yep.
so far is that every time, we get a request or a letter saying, put this on the agenda, and the same day it's transmitted to the court that this issue is pending before the commission or pending before the
I
subcommittee.
hope I made very,
It's a
very,
very frustrating scenario.
I hope I made
here.
clear that that would not be consistent with what this discussion is.
I will withdraw my
But I'm sure
amendment.
it's going to happen, whether we want it to or not. My anticipation is
let me make,
that within minutes of us taking a vote.
Just, Barry,
then
before you do,
transmit it to the parties and it'll go to the judge.
I'll withdraw my amendment. I think there's enough conversation on the record, and this video will come on. And again, should all the subpoenas fly, the video will go part of the subpoena, expressing the Commission's not lack of concern, but, we're basically following up on something. But at this point, this does not stop the train. This isn't pull the emergency brake. This isn't file charges against them. It's none of that. What we're doing is we're clarifying something that's ambiguous in the record.
Well, Brian,
I wouldn't even agree it's ambiguous in the record. There are
Right.
some people
There are
who
some-
think
right,
it's
some
ambiguous.
commissioners feel
Again,
There
and I
are
appreciate
others
that
who feel it's
clarification.
not.
So the motion is what it is, and I don't accept, Brian, I accepted Kathy's amendment.
Yeah, I pulled mine back.
You pulled yours back.
I'm sorry, can I just hear Kathy's amendment?
It was just changing the word.
Essentially, it's referring to the DNA subcommittee to see if there's a quantity of DNA that needs to be used to qualify for low copy, and has an SOP evolved over the 9 years since the procedure has been done, and if so, does it require further validation? Did I encapsulate that okay?
I think so, Ann?
Okay.
Yes.
Yeah, look at it.
Is there any other discussion regarding that motion? We do have one hand. All right, Steve Hogan is indicating he wants to speak. He did request to speak prior to the meeting. Just ask if we can keep it brief.
And if you could approach the table just so we can hear.
The statute makes it very clear that one group and one group alone reviews the science and approves the science. So the statutory body, the DNA subcommittee, issued an unrestricted approval upon their review of the technical data. We don't have to go any further than that. That is what they are supposed to do. They did it, and I think it should be respected. I don't think we should relitigate matters that are exclusively within their purview that were properly passed. And as much as I'm curious by Commissioner Walsh's comment, I also think it's a bad precedent to say 9 years has gone by, we previously approved this without restriction, let's see what you're doing these days. Because I don't think that's traditionally, the DNA subcommittee is used for new technologies before they come on board. And a 9-year checkup, which is what this would amount to, is unusual and unorthodox. And I think the attention should be less on the colloquy and more on the vote that was based upon the review of the technical data. And the vote was unequivocal, and the subcommittee was empowered to make that decision at the time. So I think it should be closed.
Any other comments?
I think that science changes over time and that it's not unreasonable to ask it to be reevaluated after a 9-year period. People's opinions may have changed.
All right, anything else? All right, we have a motion. Is there a second for the motion?
Second.
Second.
All right. All in favor? Anybody opposed? All right. What was it? We have enough votes to take care of this?
Could
All
I
right, that
just,
carries.
Mike, could I just make one point here for the mental health of all of us?
What was the?
And that is, my suggestion would be, and it's just a friendly suggestion, that in terms of dealing with the federal district court on this matter, that we simply, they can get a transcript of this proceeding, they can get a copy of the discussion, and then they can get, if they want, subsequently anything that the DNA subcommittee says. I just really think that that's the way we ought to do it, because I think it's not good for us to be in the position of, characterizing, intervening, dealing with, and I certainly don't want to be a witness. I hope I can't believe I'm going to be a witness, or anybody here would be a witness if there was any further proceedings here. So I think the wise course of action is to simply provide them the transcripts, the details, the communications, and that's it.
Thank you for the advice. I certainly don't intend on providing them anything absent a request, but to the extent they make a request, I think that's good advice.
Okay, thank you.
All right, the next item we have, I believe, are lab disclosures. I think the first thing we have is NYPD.
Yeah, and the documents are in your binder for that. I'll apologize. Dr. O'Neill is not able to be present today due to a medical emergency. So I'm going to ask if you could just review those. If you have questions, we'll table them till the next meeting. And he will be more than happy at that point to address them.
Okay.
Moving to the next one is actually the New York State Police Crime Laboratory, and we have Lab Director Ray Wickenhausen present, who can address any questions. This is a follow-up to a previous report that Lab Director Wickenhausen had actually reported to the Commission. And actually, I butchered your name. I apologize. Wickenheiser, like Budweiser.
Rhymes with Budweiser.
There you go. So if anyone has any questions. If not, we actually have some some executive session business still to complete.
I'm not sure I understand this. Could Mr. Wickenhauser tell us exactly what he believes the non-compliance is and what they've been able to do? This is a retesting of somebody's. It's very hard for me to understand what this is.
Okay, this is a case where there was some evidence that was missing, and this is just a summary of what we had done to date with respect to trying to find the evidence, trying to go back through a number of previous audits, because this particular policy that was not fully being followed was detected in a previous audit. And what had happened there was staff had placed items on a counter and not done evidence transfers in real time. This was found to be not in compliance. They were told not to do it. It was still, again, within the confines of the lab, but it continued to, it reoccurred. And an item of evidence was not located. Essentially, we turned the place upside down, and it was never found. We then went back and looked at 40 of the analyst cases, re-inventoried those. Additional analysis was also performed on a number of items in 4 different cases, and no discrepancies were found. All of the lab staff were informed to discontinue the practice. We also done a number of other items which will be updated in a separate report. So at this point, this letter just encapsulates what we've done to date in means of an update to rectify that particular issue.
So my question to you is just, is there anything, has the district attorney and or any relevant courts or defense lawyers been notified about the fact that this evidence is missing? Does it have any particular significance?
Absolutely, they've been notified, and all of that has been dealt with. It didn't particularly have any impact on that case.
All right. Anything further? All right, thank you.
Thank you.
I believe our next item or items are executive session items, since they do involve matters that may lead to promotion, demotion, discipline, suspension, dismissal, or removal of a particular person. I would mention before we go into executive session, our next meeting is June 20th. With that said, do we have a motion to go into executive session? All right, do we have a second?
I second.
Everyone in favor?
Aye.
Anyone opposed? All right, then we're in executive session.
Did he give us a thumbs up that we're online?
He hit record when I was in there.
Okay. Kathy, thank you very much. We appreciate the Inspector General being here. We're back in regular session. We did not take any action in executive session. With that being said, I think the last item we have is a motion to adjourn. Do I have a motion?
So moved.
All right, a second. Everybody in favor?
Aye.
Anyone opposed? All right, thank you. I appreciate everyone's patience and work on all of our issues. We had a lot on the agenda, and appreciate everyone's help with it.